Thank you. You may be seated. This is the time set for argument in Bolerman versus Nolis, our case number 1 CV120776. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client when you begin your argument. We have read the briefs in this matter, and we've conferenced this already, and we look forward to hearing from both of you. With that, you may proceed.
Good mornings, Your Honors. May it please the Court, my name is Yvette Ansel, and I represent the appellant, Karen Bolerman, who I will refer to as Mother in this case because it's easier, and also refer to the appellee, Stephen Nolis, as Father. There are a lot of issues in this case, and I'm going to go one by one to make it easier for the court. The first issue in this case involves the trial court's violation of the parties' agreement, which was in their settlement agreement as a contract term. It was incorporated but not merged into the decree, and it was specifically in the decree.
I'd love to debate incorporation versus merger with you, but before we get there, does it even matter? Can you have a binding agreement as to child support? Child support's always modifiable. Otherwise, 318D would be unnecessary, right?
Absolutely, Your Honor. You can have a modifiable agreement in terms of the amount of child support. But in terms of what the parties' agreement were for the duration of child support, that in this case it is not modifiable.
Well, an agreement gets you by a trial or a modification hearing. Mm-hmm. But an agreement can't prevent another modification hearing, can it?
That's true, Your Honor, but that wasn't the case in this case. There wasn't any kind of a request by Father to stop the child support payments for that second semester. In fact, when this whole case started, that didn't even occur. So the petition was brought.
We're talking about when Tyler was 18 and not in school.
Correct. I mean, the trial, because as the court is probably aware, this has gone through a lot of years of litigation. So when this started, it, I believe, was in 2010. That was prior to Tyler's senior year of high school. So that didn't even occur by the time all the petitions were filed. By the time the first trial had occurred, then yes, Tyler had gone through that senior year of high school. But the problem that we're having in this argument regarding totally eliminating the child support obligation for that second semester of high school it's against the best interest of the child. It's in opposition to the legislative intent of the child support, which was specifically outlined in the case of Lee in Arizona Department of Economic Security versus Lee, which mandates that parents financially support their children until they complete high school.
Well, but what if he had just dropped out of high school and just decided to never go back?
That's a different situation, Your Honor. We're not talking about a term in the settlement agreement or mimicked in the decree where it would be until the children complete high school. The specific term regarding child support was that there was a child support obligation until the children turn 18 or graduate from high school, whichever is later.
Yeah, but let's say he's decided he's just not going to go back. Are you saying there's an obligation?
No, Your Honor.
18?
No, Your Honor. But the fact is he graduated prior to his 19th birthday. So what if you had a situation where he remained in school, but he failed out of that second semester? Would the child support obligation still apply?
Well, let me ask you a different hypothetical. If the consent decree provided the child support would continue until the child was 35 years old, Is that enforceable or unenforceable because under no interpretation of the guidelines would child support exist?
That would be unenforceable, Your Honor. That wasn't the situation in this case.
But here, then, don't we have to, you talk about the legislative intent. I think this is the only context in the law I can think of where the legislature has dedicated policy to the courts expressly. But the court's guidelines don't seem to support the position that you're advancing here. The court's guidelines say that if you're 18 and not in school, there is no child support. So why is that different from child support at age 35?
Well, because the statute actually says, and the party settlement agreement along with the consent decree mimicked this, except it left out that while attending high school. It says if you're attending high school, there's child support until you're 19. After 19, you don't get it anymore. In this case, that wasn't any different. It doesn't say while you're attending high school, no matter how long you attend high school for.
Right, but I guess my point is that to be enforceable, there still has to be a legal child support obligation in existence. Once the obligation to pay child support ends, no matter what agreement you make, it can't be enforced by contempt because there's no legal basis for it. So here, you agree with that?
I agree with that, Your Honor.
So here, if we find that under the guidelines during a certain period there was no child support obligation, then the court would have been correct to reduce the obligation to zero during that period and restart it once he started to attend school again.
Well, except that the parties contracted differently, and there has to be an enforcement of the parties' contract.
How can you enforce a contract by contempt?
Well, you're not enforcing it by contempt. You're enforcing
Petition that was filed.
Well,
there
but
was
there
no breach of contract action, right? There was a request to put father in jail.
No, that was related to the medical reimbursements. Then there was also a petition related to child support modification.
Okay.
So
where was the breach of contract claim?
Well, there was while this was going on, I mean, obviously the child support modification occurred before all of the senior year had occurred. And so there was specific discussion of what was specifically in the party settlement agreement and the decree regarding the continuation of child support. And the problem with, and courts, as you said, and I believe the case was Riddenauer, where you said that family courts are courts of general jurisdiction and they can also deal with contract terms.
I didn't say it. The court said it.
Sorry, Your Honor. But because the family court is a court of general jurisdiction, they can certainly make a determination regarding a contract term of the parties, and it doesn't make judicial sense. It's a waste of resources in order for the mother in this case to bring a separate action regarding a breach of contract. It was all within the initial determination. And in fact, it was specifically brought up in the case of an anonymous wife versus anonymous husband in 153 Arizona 573, where they had all of these different issues going on, and the court specifically said that a holding that the trial court in its capacity as a divorce court has no jurisdiction to adjudicate a husband's cross-claim results in piecemeal litigation. And that's what would occur if we had now another separate litigation regarding a breach of contract, which was already in the initial litigation. It was already a determination that the court was looking at.
I don't want to keep you from getting to your other points, but can you tell me where in this proceeding, so I agree with you that the family court is part of the superior court, where in this proceeding there was an action for damages for breach of contract?
Well, there wasn't a specific action for damages for breach of contract, Your Honor, but within the actual proceeding, the settlement agreement was brought up. I believe it was an exhibit, although I don't want to attest to that because I don't recall at this moment. But the specific terms of the parties' contract was brought up during the proceeding, and it was certainly brought up in, I believe it was a request for a new trial or a a motion for clarification for the court. So the contract term itself was specifically brought up within that initial litigation. So it was part of the initial litigation. The notion that child support could be started and stopped within a 6-month period does not make sense. It's going to lead to more litigation in the appellate court. You could have an instance where I mentioned before the hypothetical, a child in his second semester of his senior year flunked out. In this case, there was...
But he's in school. He was in school, and then he presumably starts school again the next semester. Even assuming there's some kind of contract action, it seems odd here if he has withdrawn from school. At that point, you don't necessarily know whether he's going to go back. So how doesn't it make more sense to say he's no longer satisfied that condition of the agreement, and if he starts back up, okay, then that condition is now satisfied. You'll be obligated once he's back in school.
But in terms of the litigation that's going to occur as a result of that, it's going to clog up the courts.
I don't think we need to assume that everybody's going to litigate every dollar of every case like this.
Correct, Your Honor, and I understand that.
We shouldn't design the law around the most litigious case, right?
I agree with that, Your Honor, but if you're going to have multiple decisions, and this does occur, unfortunately, these days with high school students, where in their senior year they go astray and... But
you agree, if he withdrew and never went back, there would not have been an obligation to pay?
If he withdrew and he never went back, correct, Your Honor. But we also have an instance where he applied to go to summer school as well. So, you know, why was it suddenly, are we talking about, are you supposed to be actually attending throughout the entire period? Is it okay then to pay child support if a child is attending his senior year of high school, but he flunks out?
Not a child.
Well,
he's an adult.
Correct, Your Honor, but child support does go through 19 if he's attending high school.
Yes.
So what does attending really mean? I mean, he was...
Doesn't mean withdrawing.
Correct, Your Honor, but he did attend in January, and then he did attend summer school, and then he went back the very next semester. So we're not talking about a lag of 15 years, and what's going to occur here, it's going to be harder and harder for parents who aren't getting the support necessary in order to help these children so that they can go back to high school. And one of the reasons that this child was able to return to a Scottsdale Unified District was because he withdrew, because if he flunked out, he could not have returned. So
I'm concerned about your time, so maybe
yes,
you want
okay.
to move to another issue.
Thank you, Your Honor. The second issue in this case is regarding the amount of the determination by the court of father's income, because the court calculated child support based on a 2009 income of father of $38,000. That income actually included recurring consulting income from father, but the court used that $38,000 throughout the entire period of calculation of child support.
No matter what amount the court uses, isn't he above the guideline max?
He's absolutely above the guideline amounts, Your Honor, but it makes a difference. When you're doing a calculation, it still makes a difference.
For proportional obligations, it does.
Right.
I understand. But which proportional obligations are affected by, and in what amount?
Well, it actually makes a difference in the bottom line child support amount, too. If you're using the calculator, if you put in $38,000 versus his 2010 income of $50,000, it makes a difference in the bottom line child support amount, not just the proportional amounts.
You hold mother's income constant.
Mother's income was constant.
Right, but the change results from a change in the proportion of the two incomes, not a change in the total child support obligation prescribed by the guidelines. Right?
I understand what you're saying, Your Honor. But in the bottom line child support amount, it does make a difference when you're doing the calculations. So if the court...
Would be the difference here.
Well, if the court, and I don't recall the exact numbers, but if the court had used a $50,000 income figure, which was his actual income from 2010 onward, the child support amount would have increased. But standing here today, I don't know what that amount is. But the court, once again, that's a de novo standard of review. There was evidence that showed that father was indeed earning that $50,000 from 2010 onward. There was evidence that from 2001 onward he was consulting. The court refused to use that amount in his, or said it wasn't going to use that amount in his income. However, that $38,000 figure that they used did include the consulting amount.
The court really didn't have to include any of the consulting amount, assuming the other work actually required more than 50 hours a week. Was that the testimony?
It was, Your Honor. However, that is not the case. In fact, the guidelines say that regular recurring income from all sources should be calculated regarding gross figures. And in fact, in the case of McNutt versus McNutt, full-time employment may encompass more than 40 hours per week. So since he was doing this additional consulting work since 2001, that should have been included in his regular income.
The guidelines, I think it's 5A, specifically contemplate second jobs not being counted, right?
Well, this wasn't necessarily a second job, Your Honor. This was recurring regular income from another source.
That's in addition to his first job that he said required 50 hours a week of his time.
Correct, Your Honor. He is a professor, and
why doesn't that fall squarely within this guideline as being a second job?
Well, but if and I don't count it as a second job because it was something that he preferred to do. He chose to do it. He did it as a regular means of getting his income. That should be included in the child support calculation. Once again, the focus should be on the best interest of the children. He is actually getting that income. That should be taken into account when determining child support. The next issue is the child court's failure to deviate the child support. Initially, these parties had deviated, so the deviation should have continued, especially because the father in this case was making so much more than what the guidelines amount was.
Do you have any case that suggests that a deviation has ever been mandatory?
No, Your Honor, a deviation isn't mandatory, but
Any case where a trial court has been held to have abused its discretion for not deviating?
No, Your Honor. However, the best interests of the child should be taken into account so that if these parties were deviating initially, that just there was no difference. In fact,
is this the case for us to after all these years announce an abuse of discretion on deviation, that the child's best interests truly were so neglected by this judge, who clearly spent a lot of effort calculating this stuff, that we should find an abuse of discretion here as opposed to a case where there's actual harm?
well, and here's where the harm comes in. Not as much on father paying more child support, but when the court imposed the child support obligation on mother, because she had additional monies that she needed to spend in order to see the children for parenting time purposes, that should have been deviated to zero, because her payment of child support did impact her ability to spend money in order to travel to see the children, or to have the children travel to see her.
It could have been deviated to zero, but again, we have no authority that said it must have been. And her child support, if I recall, was less than $200 a month during that short period.
It was about $200, but Your Honor, for a person who's making $50,000, it was difficult for her to come up with that amount of money, because each single trip was somewhere between $600 and $1,500, and if the children were coming to see her, that was going to be a huge hit to her budget. So it did impact her ability to have parenting time with the children.
Not expressing a lack of sympathy, but surely you're familiar with the fact that the guidelines sometimes produce awards that eclipse a parent's income entirely.
Agreed, Your
So
Honor.
this doesn't strike me as something outside the intent of the guideline.
And that's understood, Your Honor, but it did have an impact regarding her parenting time, and that obviously should have been taken into account by the court, and it just wasn't. The last thing, finally, because I want to reserve just 30 seconds, is the issue of attorney's fees. Now, however, I know that that's discretionary by the trial court, but in this case, you've got a great disparity of income, so that falls squarely within 25-324. That alone should have been enough for attorney's fees. Then you've got medical reimbursements that were not paid, admittedly, by father. He had substantial funds to pay it. He didn't pay it, admittedly. There should have been a consideration of attorney's fees, because every time you go back to court, it shouldn't be the responsibility of the party who is entitled to these monies to pay out a lot of money to be able to litigate this. Thank you, Your Honor.
Good morning. Sandra Burt for Stephen Nolis. I want to first address what Judge Swan asked. Is this the case where we should find an abuse of discretion regarding the deviation from child support? And I would argue it is not, because mother presented no evidence to support a deviation in this case. Simply requesting a deviation later in a motion to reconsider and a motion for clarification did not meet the statutory requirement or the guidelines requirement to establish a deviation. And mother is the party that had the burden of proof. So
This might not have been a bad case in which to deviate, though, would it?
well, if mother had presented evidence, then it
A
would
portion of the judgment here is for $20. And
Pardon
yet-
me?
A portion of the judgment in this case is for $20, and we have full-blown litigation over these issues. It wouldn't have been out of bounds in this situation for the court to have deviated.
We don't know, because mother never presented any evidence of deviation. She presented no evidence of deviation. I mean, she didn't go through what the children's circumstances were in the homes, how they lived during the marriage, what their life would have been had the parties stayed together. She presented nothing. There was nothing for this court to hang its hat on. So it couldn't make any written findings because nothing was presented to it. So I would argue that it is not a case where the court could address a deviation and whether it's appropriate. Additionally, mother appears to be requesting or arguing that there's some kind of sua sponte obligation on the trial court's part to find a deviation even when no evidence is presented for a deviation. And there is no statutory authority for the court sua sponte to find a deviation. The court can't elicit the evidence. The burden was on mother. In Nash, this court found that the burden was on mother, and mother didn't meet the burden. Regarding the income, father's income, the judge said that she was only going to use father's salary, which was $310. In reality, she used she added to that $156,000. So she used $466,000 for father's income, $38,000 per month. So she added consulting income to father to arrive at the $466,000 annually, using the $38,000 per month. She used her discretion, the judge did. She even though she said she wasn't going to use that amount, she did use that amount. And the difference, you were asking, Judge Swan, the difference in the pro rata division of expenses was 2%.
So what would be the rationale for including some of the consulting income, but not all of it?
What would be the only difference was $10,000. It would have been if mother kept maintaining that father made $600,000 in 2010, but that included his wife's income. So his actual income was, I think it ended up being $500. I'm not exactly sure, $500, $550. So the difference was between $38,000 and $42,000 per month. And the difference in the guidelines, when you add in if father made $50 and mother was making $5, was $50 a month. So, and the percent difference, the pro rata difference, it went from 88 to 91, or 88.7 to 91.2. I mean, it was a very small difference, the amount. And father said he was going to pay 100% of the twins who were living with him their medical expenses, and he was paying, during the period of time when the twins were with mother, he was paying either 88 or 90%, depending on the period.
Where in the record do you see the $460,000 entry?
I just went through the child support worksheet by the judge.
Okay, so it was the court's own child support
Yes,
worksheet?
yes. The court prepared a series of worksheets, I think 5,
Right.
because there were different periods. She used the same income for father in every period. So the judge did not abuse her discretion when she determined that father's income was $466,000 per year. And she did add consulting income to father's earnings, which did require not 50 hours extra per week. His base job at the university required 50 hours per week. His second job, the consulting job, when he had consulting work, required an additional 20 hours per week. And he testified that he completed those 20 hours on evenings and weekends. So it was, in fact, second employment that father chose to take to perhaps put away more money for retirement. We're not sure. Regarding the argument about Tyler being able, or father paying child support for Tyler after he reached his majority and was not in high school. The trial court, the superior court, the family law court, has jurisdiction and has the ability to entertain cases only pursuant to its statutory authority.
And what about Reniger?
Pardon me?
What about Reniger?
I don't recall Reniger, Your Honor.
Well, the family, there is no such thing as the family court. There's the superior court.
Well, there is, except in this case, except the family court, when it is addressing child support, the statute and the guidelines, which are part of the statute, obviously, refer to child support through a child's minority, and it can go to 18 if a child is in high school. Presently, actually attending is what the statute says. Okay. So first of all, the contract argument. There was no breach of contract that was presented to the trial court. Breach of contract was never mentioned to the trial court. In the case of McMillan v. Schwartz, where the court dealt with the contract theory regarding the spousal maintenance, this modifiable spousal maintenance obligation, evidence was presented of the intent of the parties. So they knew that they were dealing with a contract action. They presented intent of the parties evidence to the trial court so the trial court can make a decision. In this case, mother presented no evidence of intent. She simply, during one point of, I believe it was her direct, maybe it was her redirect, stated, yes, this is what the agreement says. There wasn't a follow-up question, what did you and father believe the agreement meant? It was just simply that question. There was no evidence of intent that was presented to the court. So we would argue that mother waived, because she didn't present any evidence to the court, she waived any type of contract argument. Under the merger, I don't know if you want to go into merger and incorporation, but here we have a child support provision that is in the consent decree and is in the settlement agreement. It's in the consent decree. If it was only in the settlement agreement and there was no merger, then perhaps the only way the court could have dealt with the issue would have been via contract action. But it was in the settlement agreement and it was in the consent decree, and the court before it had the child support issue regarding a child who was already 18 and who was not attending high school. And in reality, the question is whether the court would have, had father not offered, whether the court would have re-upped the child support obligation when the child went back to school in August. Once the child support stopped, he wasn't in school. It's just an issue that we've never been presented with, as family law practitioners, but father offered, when Tyler went back to school, he offered to continue to pay child support for him when he was in school, and he paid, I believe it was $1,660 per month for Tyler from August through January. Regarding the question about if Tyler had failed out of school, Lee, the anonymous v. Lee case, refers to a child presently attending, and the statute says actually attending. So this child had withdrawn from school, he was not going to school, and he wasn't presently attended, or he wasn't actually attending. He wasn't involved in his high school education at all, and he was past 18. You asked Judge Swan about how could mother bring a contempt action on the child support when the child was over 18, why she didn't bring a breach of contract claim. I believe that was how you phrased it. And mother said she didn't. It was only on the medical reimbursement. She didn't bring a contempt action. It was only on the medical reimbursement. Medical payments, medical reimbursement is part of child support pursuant to 25,500. I believe it's 9, Section 9. The trial court, we argue that the trial court pursuant to Solomon v. Finley did not have authority to entertain a post-minority child support request because the court did not have the statutory ability to address child support for a child that was not in high school and was past the age of 18. Regarding the attorney fees, the court is required to find to examine disparity of income and reasonableness of the parties. In our answering brief, we set out on page 27 probably 8 or 9 instances of unreasonable behavior on mother's part, and the court declined, after examining the record, hearing the parties testify, the court declined to award either party attorney fees and costs. The criteria is not only the disparity of income, the criteria is disparity and reasonableness, and the court found in numerous instances throughout the November 2011 minute entry that mother was unreasonable. The court did not find father in contempt for not paying the 2009 expenses, and in fact the court stated that because these 2009 expenses were mixed in with all of these extraordinary expenses that father had never agreed to, it would have been difficult for father to be able to parse out what went to one item and what went to the next. Mother requested attorney fees on appeal. All she cited in her opening brief was Rule 21, which, as this court knows, is a procedural rule. In her reply brief, she actually added statutory language. But
is there any doubt she was talking about 25-324?
Well, she didn't mention a statutory basis, Your Honor. The rule requires. Well, father didn't.
The rule's been amended to allow some flexibility in that
as of January.
Yes.
Right. Well, no, actually, the amendment to the rule says it has to be in your opening brief or your answering brief. So mother only raised the statutory requirement in her reply brief. Father then did not get an opportunity to respond because for the first time the statutory basis was presented in the reply brief.
I think the amended rule may be a little bit more flexible than you're couching it.
Okay.
Precisely because there comes a point at which in a family court case, there's only one basis for fees.
Well, mother actually cited two bases in her reply brief. She cited a procedural rule.
I don't want to hang you up.
Okay, all right, okay. Our argument is that mother is not entitled to attorney fees on appeal. The procedural rule requirement that was in effect when she filed her appeal is the procedural rule that the court would examine, and she did not present her statutory basis for fees in her opening brief. So fathers had no chance to respond to that. Does the court have any other areas that they would like me to? No? Okay, thank you.
Okay, Your Honors, I'm going to talk really quickly here. First of all, opposing counsel mentioned Lee, or actually mentioned that there wasn't a contract argument before the court. There was. The mother brought up specifically the contract in the settlement agreement. Additionally, in the case of Lee, where issues were raised in a cross-claim or counterclaim that were germane to child support, the court specifically said we see no reason to preclude the trial court from resolving those trial court issues and all issues which were germane within that proceeding. Additionally, the Solomon case that opposing counsel cited, that had to do with child support going till the child was 25 years old. That's certainly not the case here. The parties tried to stay within the statutory guidelines. The only part they left out was while attending school. So the legislative intent is to promote these children from being able to have funds in order to attend school. That did not occur in this case. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. And we'll take a brief recess.
But the boys, I guess, what's the time? Oh, he is? What's she doing in Texas? Did she get a job there? Yeah. Thank you. It's good. Oh, thank you. I know.
Anyway, I'm going to set this up there.
I know.
Here's so many great stories about how
I'll send it out. So where's your office? So, oh, that's nice. So what building?
I didn't understand anything either one of you said, but I thought it was well done.
Thanks.
I don't know if I understood everything I said. So.
There you go. Well, I had a distinct impression that Swan did.
Yes.
Yeah.
He did because he was out there.
Right.
Yeah.
No, he didn't seem to be lost at all today.
No.
The other justices were quiet.
I get the impression that sometimes they take turns like that.
I know. I don't, I always do that, and then I don't read it. So what building was you? Oh, yeah. No, food places there. Oh, good.
Joe Glenn. Damien Meyer. Nice to meet you. Yes. Yeah.
Thank you. You may be seated. This is the time set for argument in First American Title Insurance Company versus Johnson Bank. Our case number is 1CACV140190. These proceedings are being audio and video recorded. We'd ask that you identify yourself and your client when you begin. We have read the briefs in this matter and we've conferenced it. And with that, you may proceed. And you'll be responsible for reserving any time that you want for rebuttal.
Thank you, Your Honor. May it please the Court? Damian Meyer, I'm here today on behalf of defendant appellant Johnson Bank. And I want to encourage any questions from the Court. Since you've read the briefs, I want to use my time best to answer any questions that you may have. What we have here is a case where there's really no dispute as to the facts. Johnson Bank bought a lender's title insurance policy back in 2005 and 2006 for two parcels of property. There was one, they paid and purchased a title policy that had exceptions listed on exception B that was missing a critical exception, some CC&Rs from 1985 that barred or prevented any commercial development of this property. And the entire purpose of this loan was for commercial property. So
is that pretty clear from the record that was known at the time that the owners intended to develop it commercially?
I believe it is, Your Honor. I don't think there's ever been a dispute as to that, based upon the summary judgment and the cross motion for summary judgment. That's the bank's position, that it was always known this was going to be a commercial loan used for a commercial purpose. It wasn't for a residential loan.
There may not be a dispute of fact, but there's one factual question that seems unaddressed. Even with a title defect, the credit bids in this case were awfully low. Is there factual information yet to be developed about what the value of the property was with the defect as of the valuation date you seek? Because I don't think, even if you were successful, I don't think that taking the value of the loan minus the credit bid equals damages.
I would agree with that, Your Honor. And there was a mandatory arbitration provision in this insurance policy, and I think there's a footnote in one of the briefs that the parties are going to proceed to reserve all their claims in arbitration. And I imagine at that point in time there'll be appraisals and testimony as to what the value was. But that raises a good point, Your Honor. I'll just jump right into it. It's not the bank's possession that First American was guaranteeing a debt. That's not the position. We're not seeking the amount of the loan as our damages. What we're seeking is for this court to enter an order that the appropriate time to determine the diminution in value that my client suffered as damages as a result of the failure to list the 1985 CC&Rs is the difference in value at the time that the loan was made, because that's when the defect was in existence. From the moment that Johnson Bank ever issued this loan, it was severely under-collateralized, and had First American simply noted and properly performed a review of the title, it would have had those 85 CC&Rs on there, and the loan wouldn't have been made in the first place. And we have cited a couple cases, but most prominently the cases we've cited are the Swanson case and also the case out of the Federal District Court written by Judge Snow, the Equity Income Partners case.
How is that different from guaranteeing a loan? Sorry to take you back, but
sure.
If your theory is the loan wouldn't have been made, then aren't you essentially saying that they were insurers of the loan?
No, and here's the distinction on that. And I think this circles back to your first question of loan minus value does not equal damages. The claim is at the time that this loan was made, this property had a fair market value without the defect. So whatever that fair market value without the defect is, that's the number that we use, and then you subtract the fair market value of the property with the defect. That's the only change. And then whatever that figure is, that's the damages claim. It's not the amount of the loan, although, one would think they would be close if a bank is doing, is doing its due diligence and getting appraisals done and that sort of thing.
Got to think there's an appraisal in the file around the date of the loan that is at least the amount of the loan.
I would think, Your Honor, but there, a lot more of it goes into that. There could be, I can't tell you the specifics. I haven't looked at this loan file, but there could be there could be a history with the bank. There could be other reasons why a bank would issue a loan without full collateral. So I'm not going to tell you today that the fair market value of this property without the defect is the amount of the loan, because that's not going to be what we're asking for. We're just asking for you to set the date of the loan as the date that we need to figure out what that number is. Yeah. And
why is it the date of the loan as opposed to the date that the defect's discovered, as it was in Swanson?
As it was in Swanson. Well, I think if you look at the Equity Partners case, that sets forth the reasoning. The lender, let's see. And one of the reasons is the ambiguities in the policy is one of the things that Judge Snow focused on, I believe. And if you have an ambiguity in an insurance policy, it's our position that that ambiguity should be addressed against the interpreted against the insurer. And that's in the briefs, and you get to some steps before that. But the public policy here, this is exactly why we have title insurance, is to protect, lenders from this type of scenario where they make a loan that was under collateralized or undersecured from the beginning. And that's why the damage was done at the time the loan was made, regardless of whether or not a borrower defaults. The bank is undersecured, and the bank's in a position where they didn't get what they bargained for. So we're essentially asking for a benefit of the bargain. We entered a contract with First American to provide title insurance that identified all the exceptions. That didn't happen.
Isn't that policy argument closer to the issue that Judge Swan raised as to guaranteeing a loan?
But again, it's what we're asking for, not guaranteeing a loan. We're asking that the policy allows us to recover the diminution in value of the property with the defect versus without the defect. So we're not asking them to guarantee the loan. We're simply asking them to say, on the date this policy was made, what was the value? That's when you should determine what the value of the property was without the defect, as was represented as was indicated in the Schedule B of the title insurance policy.
So if I understand you correctly, what you're really saying is the measure of damages is the difference between an under-collateralized loan and a properly collateralized loan, even though that loan may still go into default.
Correct. The damages, okay, and Judge Snow talked about this, is you don't have a claim, arguably, until there's a default that takes place. But there's nothing in the policy that says, well, we have to use that date of default or date of foreclosure, the date of foreclosure, as the time when we set your amount of damages. Yes, that's when you have the right to file suit or pursue your claim, but that doesn't mean that your damages are set on that specific date.
I understand, but if I understand your position, which is interesting, it's sort of academic in a sense, because you're looking back and saying, really, insurance policy, you need to compensate us for the difference in the value of the collateral then. This loan may still go into default. We still may lose our shirts, but the collateral was worth somewhat less than it should have been on the date of the loan. Is that your position?
I believe so, Your Honor. What we're saying is we didn't get what we paid for. And the reason we didn't get what we paid for is because they missed the 1985 CC&Rs. And if they had, the fact that they missed that, my client entered a contract that maybe it would not have, but my client entered a contract, and and it's not a negligent misrepresentation claim, which is in the brief. It's a contractual claim. And my client entered a contract for title insurance based upon the fact that it was going to be insured as set forth in Schedule B. So any exception, anything that wasn't listed in that exception, we would have insurance for. And our position is that date should govern at the time that that policy was issued.
And is the primary argument you have from a policy standpoint as to why that date should be used is because the policy itself is ambiguous as to the date to be used, and therefore that should be construed against the title insurer?
That's one of the public policy arguments. So we also set forth a few others. I think there's 6 policy arguments that are set forth in our brief, Your Honor. The first one is this would encourage unambiguous policy drafting, and Judge Oberbillig even pointed that out. You know, insurance companies know how to write on the date of foreclosure into their insurance policies, and they could very easily do that. If they wanted the date to be the date of foreclosure, they can write that in there. If they want,
as a party to that insurance contract, Johnson Bank had the ability to negotiate that term as well, didn't it?
it would have. I'm in the real world. I'm not sure that there any negotiations happen with those insurance policies. I guess hypothetically, the bank may have been able to put its foot down and say, "What does this damages provision mean?" But neither party did that, and the insurance company is the one that drafted its own policy.
I just wonder about the rule, though. I mean, these rules construing everything against insurance companies seem to have come from a sentiment that consumer protection was important. I haven't heard it argued in a while that banks just lack negotiating capacity.
Well, if that's how you interpret my argument, I don't think that's what the way it was intended.
I think you're relying on a general canon of construction, but I'm wondering how applicable it is to commercial loans by banks.
Fair enough, Your Honor. And I know this is addressed in the briefs where we talk about, forgive me as I can't think of it right now, but there's a policy as to how to interpret the insurance ambiguities in insurance contracts. And first you see if it's ambiguous, and then there's a few steps you take. One of them is, okay, what's the public policy of insurance, and what are and if you look at all those things and you still find that it's ambiguous, then you interpret that insurance policy against the insurer. So that premise, that's not as a general premise as I'm not intending to be a general premise. It is in our briefs how we went through that analysis. I'm just forgetting the page it's on right now, Your Honor. But we have addressed that.
Remind me of your other policy considerations,
sure,
other than the ambiguity.
By setting the rule at the day of the policy, it creates predictability. You know, one of the issues that gets brought up here is, we're not insuring against. We don't know what the market's going to do once this loan is made. But by setting the rule that you determine the diminution value at the time of the policy, it creates predictability for everyone. Lenders, insurers, both sides know, okay, if we have a claim down the road, we're going to know where we start from. If you adopt the rule that's being urged by First American, it could be 1 year, could be 6 years, could be 8 years. You just have no predictability as to where you're going to be at insurance level, property value level, any of that. So we think it encourages predictability.
Now, for a lender's policy, this argument really only matters in a falling market, doesn't it?
Well, it helps.
If the market goes up, the lender doesn't benefit, right?
If the market goes up, nobody benefits. Frankly, we're not going to suffer any damages, and First American's not going to incur a title insurance claim. Well, so both parties benefit.
Well, okay, then let's examine that. Under your rule, if the market goes up, you would still suffer damages, right? Even though the property may be worth more with the defect than it was at the time it was purchased.
Correct.
Right? Under the rule you're proposing, you could still go back and say, hey, but wait, on day one, we were damaged. And so maybe the bank ought to get a windfall here because we can now foreclose and take our damages.
Well, I think there would be, I would anticipate you're not entitled, Arizona law generally does not allow you a windfall on a general contract claim. You're not entitled to double recovery, and I think that's what we'd be looking at there.
And I don't collateral source rule. We paid for this benefit, we should get it.
I'll be frank with you, Your Honor, I haven't thought about that question. All I could say, my initial reaction to that question is, it's a contract case. It would be a situation where I wouldn't be asking for a double recovery in that situation. The title insurance claim would not be made. I don't think it would be allowed to be made under a breach of contract claim. I understand that I don't do a lot of personal injury, but I understand the collateral source rule is a personal injury type tort thing.
It is, and that was not a perfect analogy. But let's say that there's no default, right?
Okay.
Market goes up. Five years later, everything's great with the loan, but you realize that that on day one you were significantly under collateralized, and even in the rising market, you may be okay now, you may not be okay, but you realize that. Could you bring a claim just upon discovery, because of discovery?
I don't think so, because I don't think you would have any damages at that point. And again,
well, isn't the increased risk of under collateralization a form of damage?
I don't believe it is until the note's not paid.
Well, doesn't it turn on when the security interest turns into something else? I mean, then you've got a ripe claim.
I agree with that, but I think this is kind of what Judge Snow talked about in his opinion was, just because I don't have a claim until I foreclose or until there's a default, that doesn't mean that we have to use that date to set a damages claim. So that I think that's the way to address that. The other policy arguments is it encourages diligence on the part of the title company, and it protects a lender from purchasing a lawsuit where here a loan never would have been made but for. And I guess I just wanted to point out there's a lot of cases that were cited by First American saying that the date of the foreclosure should be the appropriate date. And many of those cases were cases that dealt with missing a lien, so losing priority. And I would urge the court that those cases are distinguishable from here, where in that situation where if, let's say, Johnson Bank thought they were in first position but they ended up being in second position, well, the damages there is when you foreclose, you should have been in first position as opposed to second position. So your remedy there would be, okay, if I was in first position, I'm going to foreclose and I'm going to get what I get at that foreclosure sale. That's the remedy there. This is a case where the actual defect in title that was missed, that defect in and of itself is what actually caused and created the damages issue. So I think those cases, and the great majority of them are cases of loans of that nature. Those cases are distinguishable and separate from the case that is before you, where the defect in and of itself was the cause of the damages, and that was the same situation that was presented to the court in the equity income partnership case. And with that, I have 3 minutes of time left that I will save for rebuttal, and unless the court has any other questions for me now. Thank you, Your Honors.
Good morning. My name is Richard Cobb, and it's my privilege, together with my partner Joseph Glenn, to represent First American Title Insurance Company here before you on a matter that is of extreme importance to us. I realize that it may seem a smallest issue to the rest of the world, but in the title industry, this is really important, and we're glad to be here today on this issue.
You know, Mr. Cobb, your comment about how it's so important, and looking at the amount of litigation that's gone on nationally dealing with this policy provision, why is it that the industry has not resolved the apparent ambiguity in the provision about the date of loss?
At the risk of sounding like an apologist, it's because the courts have. If you look at the decisions from around the nation, the state of Illinois has in essence overruled Citicorp. First Midwest Bank gutted it. Every other commentator who's come along afterwards has said not even Illinois follows it anymore. Judge Snow's decision doesn't even refer to 2015-62. And it's been so uniform, except for this, that there hasn't been a need to, is my guess on it. And it's because of, I think, what was said in the First Tennessee Bank case out of the Northern District of Illinois, is the absence of explicit text doesn't make something ambiguous. In fact, if you look at the dissenting opinion in Citicorp, there's a great dissenting opinion where the court says, let me see if I can find it and give the same wording the court does. The court says the opinion today, or the dissenting jurist, says the opinion today fails to set forth any reasoned explanation for its deviation from well-established principles governing the interpretation of insurance contracts and will thus cause confusion for the trial courts in the future. And so it has. But the overwhelming majority of the courts, with the exception of 3,
You know, in looking at some of those decisions that land on the date of foreclosure, they seem to be discussing why it is that the claim accrues as of that date,
Yes.
as opposed to stating a cogent policy as to why that is the date upon which the loss should be calculated. So if you could share your observations about that, I'd appreciate it.
Thank you, Your Honor. Thank you for that question. If you look at the damages calculation that's contained in the policy, the underlying purpose or the theme that runs through those cases that puts the date of value on the date of the trustee sale is that it's more consistent with the calculation of damage that is contained in Conditions and Stipulations 5.
Well, isn't the, and I don't mean to interrupt, but the language that's in my head from the policy is that it's the words "as insured." Doesn't that suggest that it's the value as of the time the insurance contract was let, as opposed to a date of foreclosure some years later?
It would be the same either way. It's insured that way.
But the bank can say the party taking out the loan has ensured that we're getting this land free of impairments. I mean, at the time we're doing it, it seems to me that it is the date of the contract is when you're insured.
Certainly. We insure as of the day the policy is issued.
I'm a little concerned, given the implication of the as insured language, that courts may be too ready to conceive of this question as a blank slate and just make up rules. We have contractual language here from the parties to interpret, and if the contractual language says as insured, how could we interpret that to say as it might be worth if there is in the future the greatest recession in the history of the United States? None of that was in there.
It doesn't say that we insure the value on the day we issue the policy. You see, and that argument goes to the issue of, are we insuring the loan or are we insuring the land? And by the way, the
Well, you're
policy...
insuring the lender, right? The lender is the insured.
They are the insured.
And I think there's been a disclaimer of any view that you're guaranteeing a loan, which would not be a tenable reading of the policy. But this argument wouldn't come up unless there had been a general massive crash in land values, right?
That's right. Nobody makes this argument in an up market.
Right. And so who contracted for sort of a one-sided risk sharing where the insurer gets all the benefits of a recession, the lender takes all the risk, and there's no upside for the lender? It seems that when you're buying insurance, you're not contracting to take on risk and cut the insurer a break in the event things go badly. But that seems to be the essence of the position here.
Banks take risks that real estate will rise and fall. Title insurers take risks in terms of the condition of title.
Well, banks really take risks that real estate won't fall. Banks are not partners in real estate transactions. They don't get the upside. All they get is their loan paid back, right?
True.
So they hope that the real estate won't fall, but they don't take an opportunity. Insurers insure against risks. You pay for some assurance that a risk, if it materializes, won't happen. And yet here, the insurer seems to be taking the position that the risk is all on its insured.
Not at all.
Well, the risk of a declining market.
Surely, we do not insure the risk of a declining market. You cannot find that in a title insurance policy in America.
No, you can't. The question is what does the language actually insure? And I come back to the as insured language that Judge Winthrop pointed out.
I also give you, you're reading Condition and Stipulation 5 from the policy, and I also give you 11, which says that the payment of the loss will be when the liability and the extent of loss or damage has been definitively fixed.
Well, doesn't that just mean that's when you can make a claim?
No, it's been definitively fixed when you have a trustee sale and one of two events occurs. One, you can't foreclose on your insured lien because it's defective in itself, or you foreclose on it and you realize you can't sell your property as commercial. It has to be sold as residential and it's worth less money. That's when your loss is definitively fixed under the policy, and that's the way the language reads.
But again, does that language go to the accrual of the claim under the policy, or does it describe the valuation of the loss?
I'm not sure that there's a distinction there in the sense that, well, first of all, let me answer your question this way. As to the accrual of the claim, it happens all the time that there's a title defect, but the borrower pays out the loan. And so the bank does not accrue a loss. All right? And that is one of the underlying premises for the fact that states around the country are all holding that the date of loss for valuation for lenders' policies has to be the day you have a trustee sale, because that's the only day when you can really have a loss.
But why does it make sense that there's a different, if you've insured, you've said this title is free and clear, or that it can be used for a certain purpose. Let's say there's a default after 1 year compared to a default after 10 years. Why should there be that much of it? Why should there be a difference in what's been insured?
I hearken back to this court's ruling in Swanson versus Safeco. The court said that title insurance was not a guarantee, of course, and I think we all seem to be in agreement on that today. But the court used an interesting metaphor that the rest of the title industry holds like a biblical parable, may I add, and that is the comparison to fire insurance. The court reasoned that title policies did not guarantee that there would not be a defect any more than fire insurance policies do not guarantee that there won't be a fire.
But is that really, I wonder if that's a good parable, because in this case, it is only First American that can start the fire.
The fire either exists, I've also heard it said it should be used compared to a health insurance policy that doesn't guarantee you're not already sick is the real metaphor that we should all be using.
Well, but again, that means that I can only get sick if Cigna sneezes on me. Here the loss was created, right, by First American's failure to discover a title defect. There could be no other insured loss. It almost sounds like your position is geared toward insuring the loan rather than insuring against the insurer's own negligence.
Insurance policies, of course, do not cover the insurer's negligence. That's the purpose of 2015-62. You have to have an abstract. And as a side note, they could have bought an abstract and they didn't. Which is one of those things that has to be said here today before we all leave.
Okay. Recognizing that, though, there is only one insured event. And that insured event happens certainly on or before the date of closing.
No, there have to be at least two things go wrong for a loan policy to ever result in a triggered loss. First, you have to have a borrower default. And second, when you go to exercise the lien on the mortgage, it has to be defective, or when you get it back, there has to be a CC&R you didn't know about. There have to be two events. It has to be a perfect storm to lead to a lender's policy loss.
Okay, that's true, but in no default, except one in which the title plant has failed to discover the defect, is the policy going to be triggered? Right.
As a general rule, yes.
Fires can start for any reason, but in this case, it's the entity subject to some air between them. But it's basically the entity selling the policy that is the only entity that can cover the loss. So if the entity selling the policy does its job perfectly, it will never pay out.
Theoretically.
And that's unlike any other kind of insurance.
I've heard that metaphor before. I will tell you, as somebody who does this, that's not quite true. There are things that even if you do your job perfectly, you can't pick. For example, mechanically in cases where somebody starts working and you've looked at the land and you don't see anything, but then they say, oh, we potholed it, that kind of thing. It does happen.
Okay.
But to your point,
yeah.
Your point is, don't we control the risk by our ability to get in there? And the answer is, yes, certainly we have the ability to control the risk by doing a proper title search and finding the 1995 CC&Rs and putting them in a Schedule B and saying we're not insuring as to this item, right? And we don't do this, but it doesn't change the fact that when we issue a title insurance policy, what we're insuring is damage that arises from the fire. And that's why we insure your loss and we value your contents claim if you have a fire on the day of the fire, not the day before the fire or the day after the fire. It's because you have to have a loss, and when the loss occurs is the day, and as you pointed out in your questions to opposing counsel a moment ago, that policy cuts in favor of both insurer and insured at the same level. It's not consistently going to favor one side or the other to the transaction.
Why is that so? I mean, I asked the question, but I'm not sure that I still understand the answer. Why is it so that a later valuation date doesn't always favor the insurer?
Because the market goes up and down.
So that if the market goes up, the insurer is favored because there will be fewer claims.
It depends, actually.
But the value of the claim won't go up because the loan is the loan.
Yeah, but it's a little bit more complicated than that. Not to digress too far, but in a rising market, the value of the property can go up, and you don't know how much of the loan has been paid down or not. And so it's possible they've paid the loan way down, but the property's gone way up, and the policy limits can still be implicated in their entirety in a rising market. And so it gets very complicated to figure out. And the one thing that you can consistently count on is that the majority position in the United States, that you use the date of loss, does not consistently favor lenders or title insurers. It falls where it falls, but it doesn't consistently favor people like First American Title.
Okay.
Just as a matter of housekeeping, I'd like to just real quickly run through a couple of bullet points that I think are worth noting. There was a stipulated statement of 8 facts in the underlying case below. And in the briefing and in the arguing, there's arguments that are being made that I just want to point out are not supported by any of the stipulated statements of fact. They are, number one, that Johnson Bank would not have made the loans had the policy disclosed the CC&Rs. There's just no evidence of that, one way or the other. Number two, that the borrower, and I think the word was inevitably, defaulted as a result of the existence of the 1985 CC&Rs. There's no evidence of that in the record. Number three, that the bank did not know about the litigation with the borrower, and had it known, it would have wanted insurance benefits, this failure to give notice kind of argument. And number four, that the purpose of either the loan transaction or the title policy was to facilitate commercial development.
Let's go back to number two.
Yep.
I know that there's arbitration to determine damages in this case, but an understanding of damage calculations still helps to understand the basic rule. Is it your contention, let's say there were no arbitration, this is just going to go to court. Is it your contention that First American's damages are capped at the credit bid? Or could they actually be substantial because whatever the credit bid was, maybe the property didn't lose 95% of its value. Maybe the property with the defect on the date of loss had a lower value than it would have in 2006, but still substantial value.
Let's see. First of all, that issue is not before us today, and I'm going to say that I have not given that substantive thought here before in preparation of today's argument.
I don't expect we're going to decide that issue, but it informs.
But I will address one issue. If you look at the formula given in the policy, it is the difference between the property with the defect and without the defect.
Right.
And the question before this court is, what data we use when we, try to determine value. The credit bid by a lender goes to one of those two factors. It goes to the issue of the value of the property on the day of the loss. Maybe, right. That's its only value. And of course, people argue over that at levels that I can't begin to argue in the...
It's not a necessary implication of your position that the credit bid serves as a cap.
I don't propose that it's dispositive today, and I think that the law as to whether or not a credit bid is a cap is something that is well established in the state. I believe people still argue over credit bids after the fact.
Okay.
So I don't know that it should factor into this court's analysis today. One other housekeeping point that I need to mention before I use all of my time up today is that when the learned Judge Snow, whom we all respect, ruled and followed, in essence, the city court holding before the Supreme Court of Illinois gutted it, his opinion says 0 about 2015-62. His opinion is dead silent on the point, and it is my understanding, although I don't have the record in front of me, that wasn't raised in front of the good judge.
Well, I have 2015-62 up on my screen right now.
You certainly do.
What language would you like to point out?
What I'd like to point out is, and this is the point that I think lenders try to get to in states where they don't have 2015-62 type statutes, because places like California do, and you just don't see this case arising out of California, is that if you think you can rely on a policy because it's a guarantee, then you can make but-for damage arguments and say, well, then I should be entitled to the damages that the value of the property. Let me rephrase that. I would not have made the loan but for the policy not disclosing the CC&Rs. And that's why those two tie together, why 2015-62 is in fact related to this question of whether or not you can get to but-for damages. You can't. You have to get the damages under the policy.
And help me, I'm sorry, but which subsection of 1562 are you looking at? Because I was looking at the definition of title insurance, which is subsection 8.
Here you go.
Thank you. It is...
It's 2015-62-1.
I guess I should move over by the microphone, shouldn't I? 2015-62-1, and thank you to opposing counsel, talks about an abstract being something that is intended to be relied upon. And 2015-62, 5 and 8 refer to commitments and policies.
Right. And would you concede that a lender's policy is defined by subsection 8, defining title insurance?
Lender's policy is included within the category of types of products that are referred to in subsection 8, to be sure. But just because guaranteeing is used in subsection 8, which is one of the arguments that it's advanced by the bank, doesn't mean that that is what actually happens in a lender's policy, because it's not.
Okay.
Just in the 56 seconds that remain me, let me just, I guess, perhaps best summarize it this way, Your Honor. You either have to do a frontal assault on 2015-62 and say, I'm going to let somebody have but-for damages, which then allows you to say, I should get date of value as of the day the policy is issued. That's the only way you can get there. Or you have to say there's an ambiguity, and I should get there that way. And, of course, we've cited a lot of cases about many courts that don't have 2015-62 not holding ambiguity. Or you have to look at the policy, and you have to say, because of as insured, as you raised, that you can measure it as insured on the day of the policy. And the problem with that is it's as insured for as long as the policy is in force. That doesn't really refer to the day the policy is issued. That's all I have, Your Honor. Do you have any other questions for me?
No.
Thank you for your...
Mr. Cobb, could I have that?
Oh, certainly.
Thank you. A couple comments. I respectfully disagree that it requires this court to do a full frontal assault on 20-1562. We're not asking for but-for damages. This is a contract theory, a breach of the insurance contract. And if you look at 20-1562-5, it talks about preliminary report commitment binder. And it states that it means report that is furnished in connection with an application for title insurance. And here's where it gets good. Quote, that offers to issue a title insurance policy subject to the stated exceptions set forth in the report. So that title commitment is an offer to enter into a contract based upon those terms. Okay, that offer was accepted. That's, what do you want to call it? Reliance. Some people call it reliance. It's a term of a contract that says this is what we're insuring you against. So it's the bank's position that we have a contract claim here for a breach of this insurance policy based upon you offered on your title commitment how you were going to insure us. We accepted that, and that's where our claim arises from. And to the other point, we're not asking for a but-for. That comment is made in the briefs, but as one of Judge Swan's first questions, we're not saying a but-for damages would be give us back everything that we loaned you, because we wouldn't have done that but for your error. What we're asking for is set the value, set the damages figure between value of without defect, value with defect, on the date that policy was issued, on the date that the parties entered into the contract. One other comment on there's no loss before a foreclosure. That's not accurate. We represent banks all the time. Parties go into default. You do workouts. You give them extra time. You do all kinds of things where that bank or the lender or whatever it is suffering a loss before they go to that last resort of foreclosure. So there's a loss before the foreclosure happens.
Can you make a claim under the title insurance policy?
I would think I would have to look at the policy language, Your Honor. I'm not sure. I don't want to answer one way or the other. In my closing, real quick, stipulation 11B, that talks about when payments made. It doesn't talk about liability. And on the last comment I guess I'll make is I think Judge Swan made an excellent point when he said insurers insure against risk. And that's what we're asking the court for when you narrow all this down. We're asking that insurers insure against the risk, and that risk should be insured against as of the date that the policy was issued, not some unknown, indeterminate date down the line. And I thank you, Your Honors, very much for your time.
Thank you both for your argument. We'll take the matter under advisement and issue a decision in due course. Thank you.